Welcome, everyone. We're going to let everyone take their virtual seats for a couple more seconds. Good afternoon. I'm Dean Vincent Rougeau, and I want to thank you, alumni, current students, faculty, and staff for joining us. It's my great pleasure to begin BC Law's spring 2021 semester with this year's Dean's Distinguished Program, Reinvigorating American Democracy Through Court Reform. Given recent events, we are all focused on the survival and strength of our democracy, and a pillar of our democracy is the independence of the courts. We simply cannot be a government committed to equality and the rule of law without it. The planning for this program began in the fall when calls for reform to our nation's highest court were mounting, triggered at that time by Justice Ruth Bader Ginsburg's passing and former President Trump's nomination of Justice Amy Coney Barrett to replace her. Our highest court was designed to be a counterweight to the partisan branches of our government. That seemed to some to be in jeopardy, but even among those advocating for change to address this, there was little consensus about what should be done. I'm excited to welcome to our program 3 constitutional law scholars who are here to share with us their ideas for change. All 3 contributed to the New York Times op-ed collection, How to Fix the Supreme Court. So please join me in welcoming Professor Leah Littman of the University of Michigan Law School, who wrote Expand the Lower Courts, Professor Tang of the University of California Davis School of Law, who wrote Threaten to Pack the Courts, and BC Law's own, Professor Kent Greenfield, who wrote Create a New Court. I'm also thrilled to have BC Law Professor Kari moderating this discussion. I know we have much to cover, so I will turn it over to Professor Hong right now. Thank you.
All right, good afternoon, everyone. I just want to quickly get out of the way so we can hear from our panelists. So as 4 quick reminders, you can see us, but we cannot see you. And so the second thing, if you would like to ask a question, please send a message to the Q&A. As the moderator, I'll pick out those questions as they're relevant to the discussion, and please feel free to send them earlier or as early as you can to make sure that we can get to them. As a third reminder, do not use the chat, use the Q&A, because the chat has been disabled for all of you. Lastly, this is being recorded. So your comments and your voice will be frozen in time and perpetuity. All right, so with that, without any further ado, thank you all for being here. And could I start by having each of the panelists spend about 5 minutes laying out the argument that they had in their op-ed. And I'd like you to spend the bulk of that time giving the best argument that you have for your point of view, but I'd like to end it, if you could end it by saying, why would someone disagree with you? For either political or practical reasons. So Professor Greenfield, could I start with you?
Of course. So first of all, I gotta say it's a pleasure to be here with Aaron and Leah, 2 scholars whose work I admire immensely, and whose work is something I always turn to, whether it be in law reviews or on Twitter or in podcasts. So it's just a pleasure to have the 2 of you here virtually at BC, and someday maybe we can get together in person, as we used to do back in the before times. So my idea about the court really starts with the presumption, and we can question this as we go, that the court is broken, that the American judiciary is broken, that has really been delegitimized particularly over the last 4 years, but not just over the last 4 years. 16 out of the last 20 appointments have been done at the Supreme Court by Republican presidents. Meanwhile, only once in the last 30 years has the Republican presidential candidate won the popular vote. So the Republican Party really has been a minority party in the U.S. for 30 years, but they've really seized the judiciary. You know, Trump now has about a quarter of the active members of the American judiciary, Trump appointees, that is. And so starting with the premise that something should be done, my idea is that we create a constitutional court, not to supplant the Supreme Court, but to augment it. I think this is both constitutional and can be achieved by statute. Here's how it would work, at least in my proposal. So Congress can create a lower court, just like it has the courts of appeals and other district courts. This is pursuant to Article 3, and can adjust the appellate jurisdiction of the Supreme Court, again according to Article 3, and require the Supreme Court to delegate any cert petition that it grants that contains a constitutional question, delegate those constitutional questions to a constitutional court. And the Constitutional Court, I think, would be populated with judges from other courts sitting by designation for a term of years, staggered across, maybe over the for 6-year terms or something along that nature, or 8-year terms. And then that court would become a specialized court to decide constitutional cases. Now, the Supreme Court would still be able to hear petitions for certiorari from that court or appeals from that court, but only if a supermajority of the justices agreed. Currently, 4 justices can grant can vote for certiorari, can grant a petition for certiorari, but that's not a statutory limit. That is just by practice. And I think under Article 3, Congress could articulate what the rules are from a petition for certiorari from the Constitutional Court. And I think the other thing that I proposed in the piece was that this Constitutional Court should have an even number of justices, and that would ensure that only with the supermajority vote by the Constitutional Court would a statute or an action be declared unconstitutional. So in a way, it embeds a presumption of constitutionality within the framework. I also suggested that that courts of appeals could utilize a mechanism, and again, according to the statute, that would certify constitutional questions to the Constitutional Court. And I think that would give an option for courts to be more, in some ways, collaborative. And this, in some ways, also conflates with Leah's proposal to expand the lower courts, because I think, as she so correctly says, that for most American citizens, who's on the Court of Appeals is much more important than who's on the Supreme Court. So let me pause there. I think there are a couple of reasons why someone would oppose my point of view. One, and they have eagerly said so on Twitter and elsewhere. But I think one of the reasons that it seems political, that it seems, well, you're a big lib and you're just wanting to depower the Supreme Court because it's gotten out of hand and it's not going to be serving your interest. And in a way, well, I guess there's 2 answers to that. Yes, it is a response to a political situation, as a political response to a political situation. But I think you could create a mechanism, create this court in a way to re-legitimize the courts, and in fact the Supreme Court. And I think that is something that all people of all political stripes should get behind, because this court is an incredibly important thing in democracy. And we have seen in the last couple of months how important independent courts can be, and to re-legitimize it is something that we should all be behind. Let me pause there.
Okay, Professor Tang, I'll have you guys go in the order as you appear on my screen, which only I can see. But Professor Tang?
Sure. Thanks, Professor Hahn. So thanks to everybody for the opportunity to be here. I'll echo Professor Greenfield's comments of admiration for Professor Hahn, Professor Littman, and Professor Greenfield, and obviously Dean Rougeau, all the work that you've done. So let me just start up front by making very clear two assumptions, or I guess maybe observations, that underpin everything I'll say today. So observation one is that anything the Democrats might do over the next 2 or 4 years to meaningfully reform the Supreme Court or the lower courts will require eliminating the filibuster. And observation two is that any reform to the courts, the federal courts, that entails eliminating the filibuster will be perceived, rightly or wrongly, by the Republican Party as, incredibly off limits constitutional hardball that warrants asymmetrical retaliation when the Republicans next have the chance. Right. And if your response is no, the Republicans will stand down if Democrats just punch back hard enough, I guess you've been watching a different Mitch McConnell, a different Republican Party than I have, right? Remember, the Democrats punched back under the Obama administration, eliminating the filibuster for lower court judges that Republicans had blocked in sort of unprecedented fashion. And when Donald Trump was elected, Mitch McConnell didn't say, oops, our bad, you win. He punched back harder. He retaliated, eliminating the filibuster for Supreme Court justices to ram Neil Gorsuch through, obviously confirming Amy Coney Barrett in the most hypocritical of ways, and on and on. Right. So all that is to suggest that, when we're trying to decide if a given reform idea is ideal, we have to price into our analysis the fact that the other side is going to retaliate. Right. So the question isn't whether, rebalancing the court with 3 more liberal justices is good or ideal, or creating a new court or expanding lower courts. I think there are, if you could freeze it in time, that would be good, all things considered. But the real question is it ideal, given that 4 years, 8 years, 12 years down the road, Republicans, when they regain power, will add 7 more justices to the Supreme Court, 100 more liberal, conservative lower court judges, and tinker with the courts in a retaliatory way? And maybe the answer to that question is still yes, that, right, maybe it's better to have some control for a few years and then to lose those liberal victories, have them quickly overruled, than to never have power at all. I'm willing to, that's a plausible argument. But I want to suggest that there's a realistic alternative that could be better. And that alternative involves progressives continuing to do exactly what we're talking about today, to make credible threats about court reform, expanding the court, changing the court altogether, making a new court. And why is that? Well, I hope you'll forgive the parenting analogy, but that's basically been my research agenda for the past 10 months. But the argument is that threats work. Right? There's a reason that when my kids were, throwing a tantrum because they couldn't open their Christmas presents a week early before Christmas, there's a reason why they stopped immediately when my partner wisely said, you know what, kids, if this is going to be so hard to wait, maybe we should just give your presents to more needy families, more needy children, and maybe we just won't do Christmas this year. Right? That kind of threat works because even a 5-year-old understands that opening presents a week later is better than opening no presents at all. And my suggestion is that today is that same kind of threat could, I don't want to guarantee that it will, but it could have the same effect on at least some of the more institutionalist-minded conservative justices that are currently on the court. Right? If their choice is between, moving the law radically to the right in a way that provokes rebalancing the court with, 6 more liberal justices, so that all of the conservative victories that they've fought for and won are now quickly overruled, and the conservatives are serving the rest of their careers in the minority of a delegitimized Supreme Court. Right? If the choice is between that, door number 1, and door number 2, where they moderate their vote somewhat, they're still power brokers on a more centrist 9-member court, they can win modest conservative victories here and there. It's quite plausible that 2 of those justices might choose door number 2. I'll say a couple more things, right? One, there's some evidence to suggest, I don't want to suggest it's a knockdown case, but there's evidence indicating that maybe the conservative justices are already heading in this direction. Right? I don't want to argue that the court's become liberal by any means. That's obviously not true. There's some huge conservative moves in the law of late, but think about in just the past 12 months, what this court has done. Conservative justices, in many cases, more than one of them, have joined the liberals to do the following things, right? To recognize federal employment discrimination protection for LGBTQ workers. They've dismissed as moot an argument to radically expand gun rights, gun ownership, and strike down gun control in New York City. They've rejected efforts, obviously, to undermine President Biden's electoral victory. They've allowed New York State to subpoena President Trump's tax returns. They've saved DACA. They've struck down a new Louisiana abortion regulation. They've required unanimous verdicts in criminal trials. They've deemed much of Oklahoma to be an Indian reservation. And in short time here, in a few months, they're going to uphold the Affordable Care Act. Here's the last point I'll make. There's a common thread that actually runs through many of these cases, which is that in many of them, the conservative justices on the court are not relying on contestable arguments about the Constitution's original meaning or arguments about, evolving societal values. They've relied on sort of a more pragmatic, almost neutral principle, which is the idea of ruling against the side that, if it loses the case, will be better able to protect its interests outside the courts. Right? To give a couple examples, the Trump administration, it loses in its effort to revoke DACA because if it really wants to rescind that program, it can do that. It just has to go back and provide a much more reasoned, thorough explanation. Right? The Democrat-controlled House of Representatives loses its effort to subpoena a decade's worth of the president's financial records. Why? Because it can get the information it needs to legislate in other ways, less intrusive ways. And when the Supreme Court, and this is the last thing I'll say, does this, when it rules against a side because that side has the best ways to secure its own interest after losing in court, what the court does is it avoids the most divisive kinds of decisions, right? Decisions that create all-out losers who have no option, no recourse, but to rail against the Supreme Court, rail against democracy. I've suggested that in this piece that this is an approach you might call the least harm principle, and it might be the kind of moderate legal approach that can dial down the Supreme Court's constitutional docket, dial down the temperature, and help us on what President Biden has described as a sort of path to restoring national unity. Professor Hong asked, why would someone disagree? I think the best reason, and it's one that I acknowledge myself, is that maybe there aren't two justices, two conservatives who will moderate their votes. I think the Chief Justice is already there. We've seen Brett Kavanaugh and Neil Gorsuch in some cases. But maybe I'm wrong, right? Maybe threats won't work. Maybe there are enough Sam Alitos and Clarence Thomases on the court that say, we're going to move the law radically to the right, consequences be darned, and if the liberals pack the court, we'll live with that. And if that happens, then we have to have these conversations about how far we're willing to go with reform.
Professor Littman?
Even though I'm going third, I did want to echo the thanks for the invitation to be here, and also a word of admiration for the fellow panelists and Dean Rougeau. It's a pleasure to be here with all of you. So I want to make clear at the outset that my proposal is a yes and. It is not meant to be exclusive or come instead of proposals such as Professor Greenfield's or Professor Tang's. It is instead a proposal to expand the lower federal courts, the federal courts of appeals and the district courts. So the way I will present this is first explain why Congress has the constitutional authority to do this, and then rattle off a bunch of reasons why I think they should seriously consider it. Congress concededly has the power to expand the lower federal courts. Unlike with Supreme Court expansion, this is a power that Congress has exercised consistently, including in recent times. President Jimmy Carter expanded the lower federal courts. President George Bush expanded the lower federal courts. So this is something that has been done quite recently. Congress actually has plenary control over the federal courts. It could choose to establish no lower federal courts at all. And given that it has that power, it also has the power to change their size. So why do I think it's a good idea to expand the lower federal courts? Well, to begin with, that's actually where most cases will be resolved. The lower federal courts will resolve something like 80-some thousand cases a year, whereas the Supreme Court will resolve somewhere between 60 to 80. And the number of cases in the lower federal courts has far outpaced the number of judges that are actually on those courts. In fact, in some areas of the United States, you have to wait over 2.5 years after filing your case to have a trial, to have your first day in federal court. I think that's completely intolerable. And in part, just to address the gap between the volume of cases in the courts and the size of those courts, Congress should consider expanding them. I think that is or will be especially true if Congress considers doing things like abolishing qualified immunity or providing a cause of action to sue federal officers who violate your constitutional rights, or creates a federal statute that prohibits partisan gerrymandering. Creating new federal rights will lead to more federal cases, and those cases will have to be heard by judges with the time to consider them. But of course, I would be lying if I said that considering expanding the lower federal courts had nothing to do with the political composition of those courts. And in particular, the political asymmetry between the two political parties and how they have treated the lower federal courts. Just statistically, President Trump in 4 years made 54 appointments to the federal appellate courts. President Obama, over 8, made 55. Now, that's in part because, one party placed more emphasis on appointing judges, but that's also because when Senator Mitch McConnell was majority leader, he didn't allow President Obama to confirm many nominees to the lower federal courts, in addition to the Supreme Court. In fact, Justice Amy Coney Barrett was originally nominated to sit on the seat in the Seventh Circuit that President Obama wanted to fill with Justice Myra Selby, the first Black woman to serve on the Indiana Supreme Court. So just a political asymmetry in how the parties have treated the lower federal courts, I think, is one reason to expand the lower federal courts to address that. Another reason is professional asymmetry. We do not have a ton of diversity in who serves as judges on the federal courts. We have an appallingly low number of civil rights lawyers, former public defenders, immigration lawyers, lawyers who worked on behalf of consumers and economic justice, and in part just to give our federal courts, a better sense of all of the kinds of cases and work that lawyers do. That would be another reason to expand the federal courts and appoint Professor Hong while I have an audience. Another reason is to expand the diversity of the lower federal courts in other ways. Again, we have seen the diversity of the federal courts decline over the last few years, with President Trump not appointing any Black appellate judges, appointing fewer women than previous presidents. And so expanding the lower federal courts could expand the diversity of those courts as well. But I also think another reason to expand the lower federal courts is because, as currently constituted, the lower federal courts pose a credible threat to democracy. Consider some of the election cases that never made their way to the US Supreme Court. A federal court of appeals in Texas, the Fifth Circuit, invalidated Governor Abbott's expansion of voting, specifically his provision of ballot drop boxes in Texas. It concluded that, the governor could reduce the number of ballot drop boxes, and doing so wouldn't actually impede the right to vote. Or the Eighth Circuit threatened to throw out a bunch of ballots in Minnesota that had been received after Election Day. That case also never made its way to the Supreme Court. So the lower federal courts, in addition to the Supreme Court, are kind of on the brink of adopting legal theories that pose a threat to our democracy. And they also threaten to undo a lot of the policies any future Democratic administration will engage in. Just yesterday, a district judge in Texas who was appointed by President Trump invalidated President Biden's freeze on national deportations. So for all of these reasons, I think expanding the lower federal courts should be on the table. I think, what someone would say in response is kind of what Professor Tang alluded to, which is any response by the Democrats will be depicted as partisan and violating norms. Expanding the lower federal courts for partisan reasons is arguably a little bit different than prior expansions of the lower federal courts that occurred more recently. That being said, I think that there are good reasons to do so.
Okay. So now I'd like to have a couple minutes where the panelists can talk amongst each other. And I guess one question I'd have is, and on Rachel Maddow's show, Senator Schumer, who appeared, I think, a day or two ago, said that he actually supported Professor Littman's proposal to expand the court. So I guess the question is, if Senator Schumer called any of you, although you've done a great job of advocating for your own position right now, my question is, what bundle of proposals would you advocate and why? And so let me open it up to see who would like to answer that. And if not, I'll call on you. I'll cold call just like my students. All right. Professor Tang.
Yeah, so I will echo and support Professor Littman's proposal. So I think the reason why I'm not as worried about Republican retaliation to expanding the lower courts as I am to expanding the Supreme Court itself. There is a neutral explanation, and a very compelling neutral explanation for doing it. I happen to share Professor Littman's sort of mixed motives here. I would expand the lower courts both because of the substantive direction those courts have taken in the past 4 years for the lack of diversity and so forth. But I also think it's absolutely right that independently, the fact that it takes 2.5 years to get a trial in some places, I didn't know. That is a neutral reason for adding more justices that should be compelling apart from the politics. And here's why that matters, right? If we genuinely believe that we should be adding more lower court judges just for the sake of the administration of the justice system, then in theory, we should be okay if some of those judges are liberal and some of those judges are conservative. I would prefer more of them be liberal. I'd like to win elections and have that be the case. But the point is, if Republicans retaliate by adding additional federal court judges after lower court judges, after progressives add lower court judges, that's consistent with the rationale that would have been the primary public facing explanation, right? Can't make that same argument, I think, about expanding the Supreme Court. The court is deciding on the merits fewer and fewer cases each year. There's an argument that the justices have too little to do, not too much to do. And so we can't really say, oh, we need additional justices, so that we can handle all of this work. The only reason to do it would be partisan. And so when the conservatives retaliate, they're going to do for partisan reasons. And I think the cost to the legitimacy of the judiciary would be much steeper. So I would absolutely support Professor Littman's proposal.
And would you add anything else if Senator Schumer called you today?
So part of my thinking is that it's contingent. What else we should do depends on what the Supreme Court does over the next 12 to 18 months. There are many, many very smart progressive lawyers who I respect a great deal who argue, that the dark days are coming, that everything progressives hold sacred is going to be at risk over the next 2 years. And if that is true, if Roe versus Wade is overruled, if voting rights are continue to be retrenched, if gun control is struck down, right? If everything that progressives hold sacred is overruled by a 6-member conservative supermajority, yes, absolutely, we should be talking about more stringent responses. My instinct, given the string of moderate rulings that the court has issued, my instinct is that won't be the case. That's my guess. And if that's true, if the chief is able to convince his buddy Brett Kavanaugh to pivot to the center in a bunch of these cases in the same way that he has, then I'm not sure we need to actually go through with some of the more serious threats.
Call on Professor Littman.
Yeah, so what I would say is, in addition to expanding the lower federal courts, I would want to put at least 2 additional things on the table. One is a kind of reform that we haven't yet talked about, which is called jurisdiction stripping. And that's where you actually eliminate the ability of the federal courts to hear certain kinds of cases. So let's imagine, for example, that Congress passes the renewed Voting Rights Act, the John Lewis Voting Rights Act. There is an extremely high chance that the Supreme Court, as currently constituted, would invalidate that statute, either on equal sovereignty grounds or say it exceeds Congress's powers under the Reconstruction Amendments. So I think in order to protect that democracy promoting statute, Congress should consider adding a provision into the statute that says no court has the jurisdiction to hear constitutional challenges to this statute. And so that could, protect some democratic initiatives against constitutional challenges and threats from this court. But that's not going to address everything. For example, that's not going to insulate some regulations or policies of Biden executive agencies from being challenged on grounds, that they violate federal statutes. And so I think another kind of proposal that should be on the table is something like what Professor Greenfield suggested, which is expanding the court by creating another court. Or, you can expand the court by giving, some number of the current justices the ability to hear cases that arise from the Supreme Court's original jurisdiction, and then, giving the newly appointed justices the ability to hear constitutional and statutory cases. Perhaps that would not be the exact same thing as Supreme Court expansion, but it would accomplish something similar to what jurisdiction stripping would do if, for example, you appoint an even number of justices of each political party. You essentially neutralize the court's ability to undo, democratic initiatives that are resulted in the political process. So I think, in addition to the reforms we've talked about, I would want to talk to Senator Schumer about jurisdiction stripping, and some variation along the lines of what Professor Greenfield is suggesting, which is creating basically subcourts on the existing court or new additional courts. But I'd also put in a good word for nominating Professor Hong. So that's number 3.
Professor Greenfield?
I think this is one of those questions that I would have answered completely differently a year ago. There's been so much that's happened over the last year that made me really question sort of the breadth of what we should be doing, or really recommit myself to much more pervasive reform. So term limits is something that I have been skeptical of, but I'm increasingly of the mind that some kind of term limits, whether it's an 18-year term that would guarantee each elected president, a couple of appointments. I think that's a good thing. Of course, the benefit of that would only happen pretty slowly. It would only change the legitimacy of the court over time. So I do think that the fastest thing that we can do is something like Professor Littman's proposal, expanding the lower court. And a year ago, I would have been really skeptical about adding seats to the Supreme Court, but now I'm much more favorable to that, because I think we all can name 4 people that we would love to see on the court right now that would make the court a better court. My only question about whether this goes to Professor Tang's point, I wonder what it would take to make the threats of those changes credible. You may be right, Aaron, to think that there's some room for movement, but I wonder but only if it's credible threats. And how do you make those threats credible? How do you make those threats credible without actually pushing them forward on the legislative front? Because us talking about it.
I think the threats are credible if you win elections and you have majorities in the Senate and the House and you have the White House. I think the threats are credible if you don't rule them out ahead of time. If by not, unilaterally tying your hands behind your back and defending the filibuster, which fortunately the Democratic leadership in the Senate didn't do. In some sense, history is a guide here. Right, when we look back to Justice Owen Roberts, when he switched his vote, it wasn't, well, there's some evidence suggesting it wasn't actually because of the court packing proposal that FDR actually proposed. Right? We don't need to formally introduce a bill to expand the Supreme Court. It's the fact that in 1936 election, Democrats swept those elections, and Owen Roberts looked at the writing on the wall and was like, wow, I better start moderating my vote now. And he started that pattern before the court packing plan was instituted. I think that's what's happening right now. I mean, listen, if you told me 3 years ago, during the heat of the Brett Kavanaugh debacle in the Senate confirmation, that a couple years later, during an oral argument, Brett Kavanaugh would say that the same-sex marriage right recognized in Obergefell versus Hodges is a very important right. So important, in fact, that it needs to be balanced with the right to free exercise of religion, which is what he said in the oral argument in Fulton versus the city of Philadelphia. I would have fainted, right? Why is he saying that? Well, I don't think it's a coincidence that when Democrats won the White House and now have reclaimed the Senate, the justices are looking and seeing real calls among progressives, the real ability to change the Supreme Court that they've spent their entire careers in worship of. And for them to think about, moderating the reasoning in some of their opinions and even the outcomes in some of their opinions to avoid that kind of what for them would be a nightmare scenario seems to already be happening. I hope it continues. I could definitely be wrong. And if I am, we should have all these conversations about the big, sort of the nuclear options.
Well, I have another, or I just want to quickly weigh in support of Professor Lee and Littman's proposals. The Federal Judiciary Center, which is the agency in charge of all of the federal courts, testified to Congress in July of 2020, recommending expanding both district courts and circuit courts due to the workload problem. So that is on the table, and that was made in 2020. Without the veneer of partisanship. But one question I have is, how are these courts legitimate in the eyes of the public? And I ask that with the background question, with the reality is that although I practice in the Ninth Circuit, I can name all the Ninth Circuit judges. I don't think I can name the First Circuit judges. And I don't think I can even name the district court judges in Boston. Because I don't practice there. So the question is, like, given that the vast majority of the public probably doesn't know most of these judges by name, how is legitimacy established, or is it just a debate that once Congress does what it does, it really doesn't impact people? I'm curious what people think of that question.
So I think that could both be, a cost and a benefit to proposals to expanding to lower federal courts. On the one hand, the lower federal courts are just of lower political salience to most people than, say, the U.S. Supreme Court. And so that might mean that there are fewer political costs or less political costs if Congress actually chose to expand them. Because, what is someone in California going to really care about that Congress is diluting the power of Judge Menashe on the Second Circuit? Like, I just don't think that many people are going to care about that. On the other hand, that might mean it's not a proposal that has a big constituency. And so Democrats won't feel the pressure, to do this, nor will they feel like they will be politically rewarded for doing so. So I think in order for it to be successful, perhaps it could be tied to other reforms, like I said, a federal statute regulating partisan gerrymandering or expanding civil rights claims. So you say, well, look, we're creating these new federal rights. We want to give you places to hear them and increase access to justice. As far as, legitimacy of the courts go, in addition to things like sociological legitimacy, which I think you're describing, do the federal courts cohere with most people's sociological expectations about how things should be? They're also, democratically legitimate in part because they are created by Congress, a politically accountable branch, and, nominated by the president and confirmed by the Senate, politically accountable branches. And so that doesn't make them, any more or any less legitimate, than any of the federal courts, we already have, but they're kind of like a necessary component of a functioning system of government, because we need statutes interpreted, regulations interpreted, and other, legal texts in force.
Professor Greenfield, do you have thoughts on what makes a court legitimate? Especially if it's a ping pong. I mean, will it really be a ping pong of just expanding the courts with whoever has the Senate?
I think it's an interesting question to think about. I do think that there's no doubt that the court is a political institution and has always been a political institution ever since Marbury v. Madison. But having said that, I mean, I think there is some benefit to the judiciary being less political than the other two branches, and to have some insulation from it. And so in that light, I do think that what we've seen over the last few years has made the court much more political than we had seen it for much of its history. And I think that comes at some cost. I don't think it requires us to know who the justices are. I mean, when the year that I was there, one of my co-clerks was talking to Anthony Kennedy in the hallway and didn't know who he was. So even clerks don't know who the justices are sometimes. But I do think that there's got to be some sense of that they're the grown-ups in the room. And I guess one of the questions that I wanted to ask Aaron and Leah is whether you think the behavior of the courts over the last couple of months do you think that it's made the courts more or less legitimate than they were before November 3rd?
So I think the answer is more. I think the consequence of rejecting Texas's founded challenge to the election results on 7-2 or 9-0 grounds, depending on how you want to cut it, has to contribute to the court's legitimacy. But, you know, here's this is another way of trying to of cutting or saying what I've been saying. If you had to guess what year in which, Gallup's been doing this for 12 years, they've been recording public approval ratings of the Supreme Court along party identification, right? So we're separately polling, you know, or collecting data on how much Republicans and Democrats support the court. If you wanted to guess which year in the past 12 years Republicans and Democrats were closest in issuing high support for the court, would you guess that it was last summer? Because it was, right? So last summer, not only was it the highest raw approval rating of the Supreme Court in over a decade, 58% of Americans supported, approved of the job the Supreme Court was doing. It was nearly uniform across partisan lines. It was, I think, 60% among Democrats and 56% among Republicans, right? And that's the number I want to suggest if we're thinking about legitimacy of the Supreme Court, that matters, right? There are misleading numbers from 2018, 2019, where, you know, 55% of Americans support the Supreme Court, but it's like 90% of conservatives and, like, you know, 15% of liberals, right? But when the court earns the trust, the approval of all Americans across the political spectrum, like it did this past summer, because of, I think, the mixed bag of rulings that it issued, and I suspect will continue to be the case, especially after the court upholds the Affordable Care Act. I think that's the best sign of legitimacy, and it's a sign that, you know, maybe, at least with respect to the Supreme Court, we're searching, you know, we're giving solutions in search of a problem, to the extent we're trying to fix the legitimacy of the court right now.
And I listened to strict scrutiny. So Professor Littman, I know you might have some thoughts on the public support of the Supreme Court over the summer.
Yeah, so I just don't think that those numbers are particularly relevant. You know, I, again, like, don't think that people are sufficiently, like, well informed, particularly about the lower federal courts, for those numbers to really tell us all that much about, you know, people's views about the court. And also, I don't think that the, you know, lack of legitimacy about the Supreme Court necessarily comes from, you know, purely public approval, but instead, you know, whether the court is particularly bent on pressing views that are increasingly like a minority view in the country, and, you know, kind of markedly or noticeably so. But, you know, I guess what I would say there is, I don't think that what they did this summer should affect our perception particularly well about the court. I think this is meeting an exceedingly low bar. You know, were you willing to overthrow the results of a landslide election after it was carried out? No. Do you want a cookie for that? I mean, I guess I'll give you a cookie, but I don't think you should win an award. And, you know, I think that's kind of doing the bare minimum of their jobs, and doesn't, in my view, meaningfully counsel against thinking seriously about judicial reform.
And then there are two questions from the audience that I just want to throw out. There's one theme that has come up where people are asking, what do you think is lost by not having a Federalist Society viewpoint expressly on this panel? Or what? How do you think the conversation would change if someone who was more clear, you know, had that viewpoint? How do you think that would change the conversation over court reform?
I mean, I don't think the Federalist Society viewpoint on this is particularly complicated, so I can give it. If readers are interested, Randy Barnett has an op-ed in the New York Times that ran alongside in, you know, that package in the New York Times that I think lays it out. You know, the conservative viewpoint is, we won, we got our justices, and, you know, this is our ball, we're going to go home, nobody else can play. Let's just stick with the court as the way it is. Anything the Democrats might do in retaliation is illegitimate. Let's propose a constitutional amendment to stop proposals to pack the court, right? This is why Mitch McConnell was so eager to get an ex-ante agreement to eliminate the filibuster, largely to prevent meaningful court reform. I think the conservative viewpoint is, what we've got is great. Let's protect it at all costs. It would be nice to have that somebody else make that viewpoint other than me, but I don't know that there's much more to say about it other than that.
So if I can just add in, so one is I would be saying the same things that I am saying now on such a panel. And two, in addition to the things that Professor Tang noted, I think, while I was noting the kind of asymmetry in the political party's approach to the federal courts, I think as Professor Tang and I were suggesting, one response to any court reform proposal will be that those proposals, are breaking some political norm, which is, exercising power over the composition of the federal courts for political reasons. Now, while I think, Republicans have already broken those norms, whether it's abandoning the filibuster for Supreme Court nominees or, doing an about face and confirming Justice Amy Coney Barrett while an election is already underway, and certainly within the last year of a president's term in office, which was their stated basis for refusing to confirm Merrick Garland, one response that I have heard is that, well, in those instances, the Senate and Congress didn't exercise the power to pass laws. And so, right, it's like an additional breaking of a norm for Congress to pass a statute that actually exerts political control over the courts versus just, the Senate exercising its power to hold a hearing or confirmation, and that is somehow escalating it. I don't find that particularly persuasive. I don't find action and action distinction particularly persuasive. I think they can both be as detrimental to political norms as one another, but that's another kind of layer of the debate.
One other thing just to note is that Stephen Calabresi did have a piece in the New York Times along with us. He was a co-founder of the Federal Society, and in fact, he wrote in support of term limits. Now, I think the other thing to think about, just in terms of this panel, and I don't want to go too meta here, but it's, I think for decades now, people on the ideological right have cared a lot about the Supreme Court and about the judiciary. And in some ways, you could see this panel, and in fact, most of our essays in the New York Times, as trying to convince the left to care just as much as the right has cared for decades. I remember back in, when during the presidential primaries, where we had 2 days of Democratic candidates every 6 weeks debating. I think there was maybe one question in all those debates about the Supreme Court. The left just has not talked much and cared much and voted much on the Supreme Court. So in a way, this is an effort to say, the progressives should care too, and so the just like the more conservatives have cared for decades.
And another question that's coming from a theme of questions that are coming from the audience is, Professor Littman, people are shocked to hear that Congress can have jurisdiction stripping powers, which to me means that they've never practiced immigration law or environmental law, because under President Bush, the Congress and the Bush passed a number of laws where actually the federal courts today are precluded from entertaining a number of challenges to environmental regulations and immigration decisions on factual matters and discretionary matters. So Congress has done that, but could you comment more about those laws? And an interesting question that one person had is, how are those constitutional?
Sure. So it's in part because Congress has the authority to control, the lower federal courts and choose whether to create them. The Congress also has the lesser power to establish their jurisdiction. The Constitution also gives Congress the power to make exceptions and regulations over the Supreme Court's appellate jurisdiction. So there's a textual basis for Congress controlling the Supreme Court's appellate jurisdiction, as well as the jurisdiction of the lower federal courts. As Professor Hong noted, this is a power that Congress has exercised, though it has done so in areas that have not attracted, widespread political attention, not allowing the federal courts to hear certain fact-based challenges to immigration decisions, not allowing the federal courts to hear certain challenges to environmental regulations as well. This is also, sometimes occurred in other areas as well. So Congress eliminated the federal court's ability to hear cases involving a specific Indian reservation. And the court concluded that jurisdiction stripping provision was constitutional in Patchak versus Zinke. Congress's ability to control the jurisdiction of the lower federal courts is not entirely clear. like, we don't know how far Congress's power extends, but it is a power that Congress has long exercised. We just don't know whether it allows Congress to, say, eliminate all Second Amendment, all First Amendment, all Fourth Amendment cases from the federal courts. But we know it at least extends to, among other things, eliminating the federal court's ability to hear Administrative Procedure Act challenges or other challenges, regarding the Secretary of Interior's designation of certain lands, as a tribal reservation. That much is clear, but again, we don't know how broad it extends. There would certainly be debates and cases about whether particular jurisdiction stripping provisions are constitutional. But I would say basically everyone agrees Congress has some power to strip jurisdiction of the federal courts, but it's not at all clear how broad that power is.
And then another question that came up is, are we having this debate now because the court has always been political, but now it's expressly partisan?
I do think the partisanship of the court is worse now than it's been in decades. I mean, I think, if you look at these charts that analyze shifting groups within the court, I think the multitude of groupings was much higher in previous decades. And the other difference is that now, like, the partisanship is party based. There have been many cases through the years of Republican appointed justices, William Brennan, for example, David Souter, for example, voting in the liberal camp, and more conservative justices, Byron White comes to mind, who are appointed by Democratic presidents. But now you have a pretty hard set partisan divide, and the partisan divide correlates exactly with the party of their appointing president. So I think that's a difference, and that can be a problem.
Can I just add something really quickly? I agree with Professor Greenfield. I also want to point the blame for why the court has gotten so much more partisan a little bit at ourselves as constitutional scholars and constitutional theorists. One difference between the partisanship today at the court and the partisanship, say, of the New Deal era, where all of FDR's nominees voted to uphold all of his laws, right? That was just as partisan in terms of a Democratic president votes to support Democratic laws perspective. One difference is the way that the justices are rationalizing their partisan outcomes. We have an overconfidence problem in constitutional law. We have an overconfidence problem in the Supreme Court today. Aided and abetted by theories like originalism or common law constitutionalism or living and you pick any number of theory on the right or the left that the justices, constitutional pluralism can point them to the one and only right answer in these really hard, complex constitutional disputes for which really there's good arguments on both sides. The justices today now think they can discover the answers to these hard problems, and unsurprisingly, when the evidence is ambiguous, what they actually find is likely to be their own political preferences, and therefore partisanship is amplified, right? Overconfidence bias is what Daniel Kahneman, the economist, has called the most damaging of all cognitive biases because it makes every other bias worse. Notice how different that is than the 1940s New Deal, settlement court, where all the liberal justices were saying, we're going to uphold FDR's laws, not because we know that they're constitutional, we can tell you the one right meaning of the Commerce Clause or the Spending Clause, but rather because we don't know. And we're therefore going to defer, we're going to be humble, we're going to defer to the judgment of legislatures. That's a very different reason. When justices are honest with the American people and say, these are hard constitutional questions, we don't have any special, we're lawyers, but we don't have the answers to all your problems. We're going to leave some questions up to the political process. And yes, there have to be some limits. And so we'll need to negotiate that down the road. But I want to suggest that constitutional theory is partly to blame for this overconfidence problem and therefore the partisanship that we've seen increasing at the court.
So another question I have, so when all three of you made your proposals, and obviously when you were invited by the New York Times to write your proposals, none of you chose just to expand the court outright. And I'm curious why that is. Professor Littman?
I guess two reasons. I just don't think court expansion by itself is a solution to the many problems that the court system faces more broadly. I think it runs the risk of escalation. It runs the risk of further politicization of the court. And I think in an ideal world in our system, as Professor Tang was suggesting, the federal courts would just be deciding fewer things, particularly constitutional issues, and would defer more to the political branches. And I just don't think Supreme Court expansion is, part of the path to get there. Part of why I'm excited about expanding the lower federal courts is there, the federal courts have a lot more business than just deciding whether federal statutes are constitutional. And I think, we need judges to actually do that business. So I would be in favor of proposals that seek to, depoliticize the court and take more constitutional issues out of the Supreme Court rather than proposals that kind of, give one side a better audience with more of its constitutional issues.
Professor Greenfield?
Yeah, I think I'm worried about the possible ratcheting effect, which we've talked about already today. But again, that I think given where we stand, I'm less skeptical of it, or I'm more willing to think about it as a possibility than I was even a couple of months ago. But I do think that if I were prioritizing things, I would put expanding the lower courts as more important than expanding the Supreme Court.
Professor Tang?
The only thing I'll add to everything I agree with from Professors Littman and Greenfield is there's an opportunity cost question here, right? To expand the Supreme Court, not only will it provoke retaliation, will provoke all-out war just to secure that single proposal. And if Democrats are going to go to all-out war to eliminate the filibuster and to go to the mat for something, I would rather they go to the mat for Puerto Rico and DC statehood, which will marginally, not all the way, but counterbalance the Republican bias in the Senate. That's for pure geographic and demographic, the malapportionment of the Senate. I'd rather go to the mat for voting rights. I'd rather go to the mat for other legislation, an effective COVID response in this particular moment. Are I think things more important. The name of this panel is Reinvigorating American Democracy Through Court Reform. It shows that court reform is a means to a much more important end. I'm not sure it's the most important means. If Democrats have one or two bullets to fire, there are other bullets that might be more worthwhile.
My only response to that is, that I agree with Leah on this, that, court reform is democracy reform. We need a massive reinvigoration of democratic norms, and we can work through that by way of statute. We should make election day a holiday. We should have universal same-day voter registration, et cetera, as you've said, Aaron. But I think without court reform, those democracy reforms are fragile. So in some ways, it has to be a part of the package.
And so a corollary to that question was asked by someone else, where do you ever feel that Democrats bring a knife to a gunfight? It seems to me that the Republicans were in the same position as the Democrats currently in. They would pack the Supreme Court, add seats, and continue to politicize the high court. And argue that might not be hypothetical, but are we being too cautious?
I'll quote our colleague Mark Roden, what somebody said a few months ago, which is, "I'd be happy with a knife," but they've been bringing noodles to a gunfight. So maybe we should become more aggressive, I think, on this front politically.
But then all of you stopped short of calling for the court outright, which I think is really notable. Professor Littman?
Like of calling for the court outright, calling to expand or abolish?
Or calling to expand the Supreme Court outright.
Yeah, I mean, again, I just think if we're talking about ideal reforms, that's not my ideal reform, because I do think court reform is a part of democracy reform. And my ideal vision of democracy is the political branches get to pass, democracy enhancing legislation. One way to do that would be to pack the Supreme Court with justices who have views that are much more deferential to the democratic process, and also justices who are not inclined to, invalidate democracy enhancing legislation. But again, in my preferred world, we just wouldn't give them the opportunity to weigh in on that democracy enhancing legislation. And so that would be the structure that I would create.
I'll start to sound like a broken record here. But the gunfight analogy is actually an interesting one. Guns are terrible things. Nobody wants to be in a gunfight, right? And so, but why would you bring a gun to a gunfight rather than a knife? Because if you're holding a gun, the other person holding a gun is less likely to shoot. Right? This is, the mutual assured destruction kind of idea. But here, the actors external solutions, political solutions are going to be solutions, packing the court, beginning more packing, are just going to end in this, horrible, vicious cycle that leaves the Supreme Court unrecognizable to us all. And maybe that's better than the court today. I don't know. You can make that argument. I don't think so. But the best actor to fix this problem at the Supreme Court, so that we can spend our time focusing on expanding the lower courts, other legislative proposals we've talked about, are the justices themselves. The best case scenario I want to suggest that we could have is what happened after the FDR court packing proposal. We have where the court pivots to the center, defers to the political process, and eventually, right during the civil rights era, it can't absolutely defer. There are some laws, obviously, that cross constitutional boundaries, and the court has to enforce those. But in general, which Professor Littman has just said, judges that are more inclined to, as the chief wrote has written in some of the COVID cases, right? Who is he to second guess elected legislatures who think they're going to save lives by restricting the number of people going to attending worship services, right? Obviously, he's now a minority view. So, I've sort of gotten lost in the words here, but I think we bring a gun not to use it. We bring a gun so that we don't have to.
Well, along those lines, could the panelists talk about what's been happening with the shadow docket under the Trump administration, and the impact that that has both on the Supreme Court right now, and then the directives that it does have for the lower courts, especially, as relevant as yesterday's immigration decision. Professor Littman, could you comment about that?
Sure. So the shadow docket refers to the cases that the Supreme Court decides on an emergency basis, so without oral argument and without full briefing. Sometimes in these cases, they don't even issue opinions at all. Instead, there will just be an order that says, we grant a stay, essentially putting on hold a lower court decision. So there have been several extremely significant shadow docket cases. Some involved the election, and they were about whether to put on hold decisions that invalidated state laws restricting the franchise or expanding the franchise. Some involved the Trump administration policies, such as the ban on transgender individuals serving in the military. The reason why the administration was allowed to put that policy into effect is because the Supreme Court stayed a lower court decision invalidating it. There have also been coronavirus cases on the shadow docket, as well as most recently cases involving the resumption of the federal death penalty. And I think, the federal death penalty is in some ways, perhaps I think the best indication about why I am less optimistic than Professor Tang that there is a moderating direction on this US Supreme Court, because one of the last decisions that they issued was a decision in which the court reversed a decision of a district court, skipping the step of the Court of Appeals, which is just institutionally wild. They didn't explain why they were reversing the decision. Instead, they just did so in order to allow the administration to execute someone, before Joe Biden became president, and put on hold again the federal death penalty. So there have been a number of extremely significant cases on the shadow docket, not just cases involving the federal death penalty, but also coronavirus and others.
And Professor Littman, do you think the Biden administration should also be exercising the shadow docket, or and could you explain what it means to skip over the circuit court and why that has been happening?
So what it means to skip over the circuit court is essentially the administration will run to the US Supreme Court and say, we want you to put on hold this lower court decision, perhaps because the Court of Appeals elected not to do so, or perhaps because they just think they have a friendlier audience at the US Supreme Court than the Court of Appeals. I think the Biden administration might want to try, in the event that some of its policies are put on hold in the lower federal courts, like this federal court decision pausing the national deportation freeze. But the reality is it doesn't have a friendly audience at this Supreme Court. So it knows its chances are probably less favorable at the US Supreme Court than in many courts of appeals. So they just lack the similar incentive that the Trump administration had to run off to the Supreme Court. And I think, honestly, the Trump administration's behavior underscores what Professor Tang and Professor Greenfield and I have said is true about the Supreme Court, which is it is more politically polarized. One political party knows that it has a more receptive audience at the US Supreme Court than another political party, and that's just a reality. And the party's behavior and the administration's behavior reflects that.
And we have about 10 more minutes. Professor Greenfield, is there something that hasn't come up that you think would be important for the audience to consider?
Yeah, I did want to just weigh in for a second about your previous question about the shadow docket. I think the shadow docket has became much more important during the Trump administration. The Trump SG was much more aggressive than the Obama SG in litigating things in the shadow docket, moving cases through the shadow docket very quickly. And I think that comes at a real cost. One of the things that we talk about in my Common Law 1 class is one of the ways that the court develops legitimacy and maintains legitimacy over time is by giving explanations, right? Explanations is something that the other branches don't have to give. They don't have to make sense, but explanations that the court gives, we can analyze and think about and evaluate the explanations that the court gave 2 centuries ago and try to figure out whether it makes sense or not. So I think when they, and this is true for the courts of appeals too, they're increasingly issuing opinions that are not published, that are not worthy of, they can't be used as precedent. And I think that comes at a real cost, because I think making people explain, making people sign their name to something is a real constraint on decision making.
Professor Tang, do you want to weigh in on the shadow docket before moving on?
I don't think I have anything to add to the great points that Professors Littman and Greenfield made.
So Professor Tang, I'll kick this over to you. Is there something that hasn't come up yet in this discussion that you think would be important when thinking about the larger themes of democracy and court reform?
I think inevitably in these kinds of conversations I have with students and others, it's kind of demoralizing. We're searching for a least bad solution because all of the proposals that we've talked about come with some real costs that the folks have identified. And the one thing I want to suggest is, when we're choosing among a menu of least bad solutions, one of those things that you should consider is waiting and seeing. And it's not popular. There's a part of me that hates this idea precisely because we have been bringing what Professor Greenfield eloquently described as a noodle to this gunfight when Republicans keep ratcheting up the constitutional hardball and breaking norms, and then accusing Democrats of thinking about breaking norms. But sometimes, there needs to be an adult in the room. And it is possible, again, it's a contingent case, we'll wait, we'll see. Professor Littman could well be right about the direction this court is going to take over the next 2 to 4 years. But it is at least possible that John Roberts is the adult in the room, that he can convince either Justice Kavanaugh, or Justice Gorsuch, or Justice Barrett, or some mix of them in some meaningful number. Progressives aren't going to win every case in the Supreme Court. They're going to lose a number of cases, criminal law cases, death penalty cases. They're going to lose. But when the question we should ask is, when we sit back and look at the full picture of what the court is doing, are they issuing decisions that losing groups really just can't do anything about. Decisions like campaign finance reform, like Citizens United, where there's just nothing we can do to fix the political process but amend the Constitution. Those are the worst kind of decisions that the court can issue. How many of those kinds of decisions is the court going to issue over the next few years? That's what we need to be watching for.
Professor Littman?
This might be something that we've already touched upon, but I just wanted to reframe it, which is when you're thinking about court reform, one question that I always encourage people to think about is ask yourself, what is the problem you are seeking to fix? Because you can't come up with a sensible reform unless you have a grasp on what the problem is. And that's part of why, in your response to your question about why my proposal wasn't expand the Supreme Court, I said, because I don't think the problem is just the partisan asymmetry or the fact that the court isn't representing, a majority of views in the country. The problem is that we have an institution that is itself less democratic than the other branches of government, deciding the same issues that the political branches are and are telling the political branches they can't do certain things. And I just don't think that is the ideal arrangement for a constitutional democracy. And so we should try to rebalance that equation by taking more constitutional issues out of the court, not just, addressing the kind of partisan composition of the Supreme Court.
Professor Greenfield?
Yeah, I think those are really good points. I do think that this is an enduring question. Should judges be humble, or should judges be deferential? And of course, it depends on the situation, right? Like if states are throwing up obstacles to the ability of people to get abortions, I want judges to be able to step in. But if Congress is trying to expand COVID response, for example, or the protections for people to be free from discrimination, I want judges to be deferential. So, and of course, the difficulty here is you've got to create rules that apply regardless of whether you agree with the statute or not. So I think the difficulty here is an age-old difficulty, but the real I think check on it is that more or less the Supreme Court and the lower courts ought to reflect the country as a whole, and within some wide constraints. And I don't think that's true anymore. I think the courts are mostly reflective of a pretty minority set of viewpoints about the law and about legal interpretation. And I think the number of originalists, for example, sitting on federal courts is quite high compared to the number of originalists in the legal academy, for example. I think originalism is a pretty narrow niche point of view within the legal academy, and and that may reflect something about the legal academy, but also I think it reflects something about whether after a hard look, whether originalism is really defensible as a way of making decisions. But I think we find that the Overton window in the judiciary is much further to the right than the Overton window in American generally, and even among legal scholars in particular. So, and I think that's a problem.
One final question, hopefully we can get to this. Professor Lonnie Guinier once said years ago that what makes democracy different from any other system is that at the end of an election, the losers concede. And she said that's critical because the losers have a buy-in to the system and they know that they just have to reorganize. When it comes to a court case, every decision has a winner and has a loser. And in many ways, this court reform has come about because the progressive feel that we have been losing. So the question is, how can people lose at the Supreme Court or in the federal courts in a way that still feels fair and allows for a buy-in? Professor Littman?
So one example I would look back to is just, when you didn't used to be able to predict how a justice was going to vote based on the political party of the president that appointed them. when people walked into court, when Justice O'Connor was, say, the median justice, or even for some issues, Justice Kennedy, I think most sides on a bunch of major ideological partisan issues felt like they had a fair shot because they didn't know how those justices were going to look at the case and ultimately come down. And I'm just not entirely sure that remains the case today.
Professor Tang?
I agree with that, but I think there's another thing that matters, and that is what the losing group can do after it's lost. This is a distinction that we don't pay enough attention to. Sometimes when progressives have lost big cases in recent years, they've had easy options for fixing or securing their interest afterwards. A great example is Janus versus Ask Me Council 31, the public sector unions case, where the Supreme Court, 5 justices, conservative Supreme Court, basically eroded, gutted the major source of stable public sector union funding, fair share fees. And commentators, myself included, predicted this would be, a doomsday scenario. Unions are going to go bankrupt. Turns out I was wrong. We were wrong because we underestimated how good unions have been at organizing. Right? Basically, the Supreme Court said you can't force objecting members to pay union dues, but union members can voluntarily join the union and pay dues if they want. And most economists out there said, why would anybody voluntarily join the union if they can benefit from the union's representation, the 13% wage premium and so forth anyway, so they're just going to free ride. Well, so far that's been wrong. In the 1 year after Janus, public sector unions actually increased the number of dues paying members, not decreased. 9 out of the 10 biggest public sector unions had more money in their budgets afterwards, precisely because they organized, they responded to the Supreme Court defeat. They had an option: persuade people to join voluntarily, lobby for state laws, ensuring that they have access to meet with new employees so they can show them the benefits of union membership, right? That's a decision that everybody thought, all progressives thought was going to be terrible for progressives afterwards. There's a reason why people aren't talking about it 2 years as being the end of unionism. Contrast that decision, a decision where progressives have a response afterwards, with a case like Citizens United, where literally there's nothing we can do to protect democracy from the corroding influence of unlimited corporate expenditures other than a constitutional amendment, right? We've tried all these other options. And so therefore, when the Supreme Court issues decisions like Citizens United, there's a reason that has a huge cost for its legitimacy. Democrats, moderates, even many Republicans are furious about the decision because there's nothing ordinary citizens can do about it. But Janus doesn't have that same kind of cost. Those are the kinds of things that I think the current Supreme Court, the Chief Justice in particular, is now thinking about. Which side, if it loses the case, can I make sure it has something it can do about it, take matters into its own hands, so the court isn't the be all and end all, the end of the story. It's just, the opening chapter, and then, people go back to the democratic process, or they engage in private ordering to fix their problems. That's, I think, the best thing the court can do to protect its legitimacy.
And on that, we will end. Professor Greenfield, I apologize, I'm not to be able to get your insight on that, but I personally would like to hear what it is after the panel. But with that, Dean Rougeau, would you like to have any ending thoughts?
Well, I just want to thank our panelists for a really wonderful conversation, and just to emphasize how important it is that these conversations continue. I thank you for being so willing to share your thoughts and your creativity, and to really remain open and honest about the pros and cons of all of these things. But at the end of the day, we all have to commit ourselves to making sure that our democracy retains its legitimacy in any way that we can, and that we also approach this conversation with some humility. You all mentioned both those things, and I thought that would be a great way to end. So to Professor Littman, Professor Tang, and Professor Greenfield, my deep thanks. Thank you for sharing with us today, and we look forward to more conversations in the future.
Well, thank you all for a wonderful panel.